Hi, I'm Jeff Siegel, founder and CEO of Medical Justice and eMerit. We're here today with our General Counsel, Mike Sakopoulos. Mike, tell us a little bit about your background, training, experience, and what you do.
Well, thanks for having me. I've been General Counsel of Medical Justice for over 15 years, practicing attorney, and I'm also president of Medical Risk Institute, which focuses on HIPAA and privacy compliance.
Mike, let's talk a little bit about HIPAA. What has changed and why do doctors need to care about it? I know that when I practiced, I had heard about HIPAA, but it didn't seem to be an emerging or evolving threat. What's different?
So this is not your father's HIPAA. It started in 1996. There were no penalties until just a few years ago. Now we're routinely seeing multi-million-dollar fines being assessed. We now see open audits being conducted without any complaints being filed. Just randomly, like your taxes could be audited, we now have HIPAA audits the same way.
So who gets audited? What would put someone in harm's way, or what's the likelihood of a doctor even being audited? Can most doctors safely ignore it, and if they receive a letter, then jump into place right when that happens?
It's not something that you can instantly put a fix to. This is something that you need to plan ahead for. And so if you receive a notice of an audit, which can come either from a complaint-driven, and we know that there are tens of thousands of complaints filed on the Office of Civil Rights website each year, or it could be one of the thousands of random audits that occur each year now that the Office of Civil Rights is geared up to do that. Once you receive the notice, it's much like the black spot in Roger Louis Stevenson's Treasure Island. You need to act quickly because here it comes.
When I think of HIPAA, I think of what I'm not supposed to do, meaning that I'm not supposed to disclose protected health information. That seems pretty straightforward. So if I just think of it of what I'm not supposed to do, what am I missing? What is the alternative universe, the things that I have to do?
So there are a number of things that you need to do. You have to have policies in place. The first thing that the Office of Civil Rights will ask for is a security assessment. This is a written document. It's supposed to be done routinely, and it looks top to bottom at how you handle that protected health information, or PHI.
How does one go about creating this security risk assessment? Do I need to be a computer IT specialist, or do I need to work with any number of vendors? Will they even know what I'm talking about?
Hopefully your vendors will know. It is a look at the IT system, but it's also a look at how your practice handles the information internally. It's not all just electronic, but certainly it's complex enough that I tell people, at least for the first time you go through it, you want somebody to give you some guidance and help you.
So information technology means the types of equipment, and perhaps I have to have the right operating system, have the right virus protection, have patches in place, et cetera, but it's more than that, isn't it? Isn't it related to how the individuals, how the people in a particular practice manage and relate to this electronic information?
Oh, you're absolutely correct. So a proper HIPAA compliance program would look at mobile device use. We all have smartphones that we use all day long, and patients I know contact providers through smartphones. Information rests on that. What are you supposed to do with that? What does the Joint Commission say? What does the Office of Civil Rights say about how you keep information, how it gets uploaded or does not get uploaded to your electronic medical records? There are a number of things that are several layers deeper than what would just appear on its face as, oh, we just need to protect this information.
All right, so look, let's drill down. Let's talk specifics here. Okay. What happens if, most doctors that I know can't get it all done at the office. So they take their laptop home, they take their smartphone home,
sure.
And somehow, let's assume the laptop or the smartphone gets lost. Is that a problem?
It is a problem. In fact, if you look at breaches that were reported just in the last 12 months, the category of lost devices, whether it's a smartphone or a laptop, comes in the top 3 categories of breaches. So it is definitely a risk category and one of the leading risk categories.
So what if I've taken the time to encrypt my laptop, it's password protected. Same with my smartphone. Does that help mitigate the risk? Are these things that I should be doing preemptively and proactively before there's a problem?
Absolutely. In fact, if you've encrypted to the proper standards under HIPAA, which uses NIST standards, National Institute of Technology standards, then you're okay. You've not had a breach. So if you have the right infrastructure in place, you're going to be okay. Now, you may have a problem if the information on your patient it only rests on the device that is now lost. You have a separate problem of not having a complete medical record, but that's different from HIPAA compliance.
What about other components that must be or should be in place before the HIPAA police show up? Let's talk about some of the documents and the agreements that you'd want in place before someone comes knocking on your door.
So you're required to have a security policy, but I think it's also a good idea to have a social media policy because so much of today's world with staff and patients revolves around social media. And so we need to have a clear document on that, and there are some out there that I think really offer a great level of protection for the practice.
And indeed, you provide this document and a host of other documents through the Medical Risk Institute. Is that correct?
I do. We try to keep our clients current on changes in the law because this is a very dynamic field, and those documents need to be tweaked and changed as rules and regulations come out.
We have an agreement, or Medical Justice and eMerit has an agreement with the Medical Risk Institute, so to the extent you're not the Mayo Clinic and you're not Sloan Kettering and don't have an army of lawyers who have made this problem go away for you, our members, Medical Justice and eMerit members, have access through a special agreement with the Medical Risk Institute to do this in a very cost-effective and easy to implement way. Is that correct?
Absolutely, and you bring up a good point because compliance is much easier if you have a huge infrastructure to do this, right? The Mayo Clinic example. But what the Medical Risk Institute focuses upon are smaller practices. And in my mind, that's much more of a trick and much more difficult to do because resources are limited and people are directly involved in the practice and need some assistance, but we can't just go all out on compliance to the extent that we shut down a practice. So it's a balance of what do you need to have under the law to fit you as a smaller practice.